Bold opinions, real evidence, and lasting impact. This is Rod's Scholarly Opinion. I am your host, Rodney McNeil, where we break down the real issues shaping our world through a lens that is opinionated but grounded in credible evidence and critical thought. Recently, the Supreme Court issued a 6-3 ruling in Louisiana versus Callais case in favor of proving a district map is no longer discriminatory based on obvious outcomes that disadvantage minority communities because of their race. Instead, there must be proof of discriminatory intent. Now, some of you might understand immediately the effects of such a decision, while others might say, well, Rodney, I never cared about or followed politics, so this will never affect me directly. Well, I'm here to serve notice on you. It does. This is a violation of Section 2 under the Voting Rights Act. But before I get into the significance of the decision and its impact, we must first understand what the Voting Rights Act is and its purpose. Back in 1870, on February the 3rd, the 15th Amendment was signed into law. This law was designed to protect the legal right of Black American men to vote. It was supposed to prevent the federal government and states from denying a citizen the right to vote based on their race, color, or previous condition of servitude. In other words, that servitude was slavery. This was part of Section 1 of the amendment. In Section 2, Congress was given the power to enforce the rights of Black citizens through appropriate legislation. This means Congress could identify discrimination, violations, and create laws for those incidents and manage both public and private individuals from continuing acts of discrimination. However, the Supreme Court ruled that the power of Congress is not absolute. Congress cannot create a new right, but they can pass laws that align with a violation. States in the South like Mississippi, Alabama, Georgia, Louisiana, and South Carolina used discriminative methods to stop Black men from voting, including poll taxes, literacy tests, and even worse, being beaten and killed. For 95 years between 1870 and 1965, Black people faced barriers, stopping them from exercising their right to vote. In 1964, several peaceful initiatives were organized by the civil rights leaders, and they were met with violence. This violence would continue through 1965 as peaceful protests, which ended dangerously. The unethical behavior against Black people in the southern states gripped the nation. Then came a turning point. On August 6, 1965, President Lyndon B. Johnson signed the Voting Rights Act into law. The Voting Rights Act enforces the 15th Amendment, meaning voting rights cannot be denied based on race. Practices like the poll taxes and literacy tests were finally done away with. But how does this relate to Louisiana versus Callais? Let's address that now. In Section 2 of the Voting Rights Act, it is a nationwide rule banning voting practices and procedures that discriminate based on race, language, or minority status. Those practices and procedures include redistricting, plans, and election-related procedures that show racially discriminatory outcomes, which I will break down and explain redistrict plans and its significance a little later. Section 5 in the Voting Rights Act highlights a change affecting voting. Specifically, the redistricting plan might not be used by a jurisdiction known to discriminate against minorities. The officials within the jurisdiction must show that their map plans do not discriminate or have a discriminatory effect. They can do this in two ways. They can file an action in the United States District Court in Washington, D.C., or submit their action to the Attorney General. So, states with history of discrimination must get federal approval or pre-clearance changing voting laws. Now that you understand the Voting Rights Act, which is a civil rights law protecting equal rights to political participation, which is voting, but who does this law protect? The primary group affected are racial minorities and ethnic people. This largely affects Black Americans, Latinos, Asian Americans, and language minorities like Native Americans. These groups throughout history were excluded from voting and political activities, limiting their representation, meaning no representation. So, the Voting Rights Act protects these groups, but the government institutions affected are state and local governments that run elections and draw voting maps, the courts and departments of justice, as well as voters nationwide. It's not just limited to voters in southern states. Now, as I stated earlier, I will break down redistricting plans and the importance of these actions. Redistricting is the process of redrawing the state's electoral map after the census is complete. This happens at the start of every decade. The official part of the state legislature evaluates and draws the district maps. More importantly, officials understand the population and each district influences who will be elected as the district's representative in government. So, these officials purposely change electoral district boundaries to give themselves an unfair advantage to winning an election. This is an illegal practice that decreases minority voting power by splitting communities across districts or grouping them into one district. Voters affected by discriminatory redistricting plans lose the opportunity of choosing the representative they want. This ties into the Louisiana versus Callais case because it marks a significant turning point in the way the Voting Rights Act can challenge these unfair maps to ensure fair representation. The Supreme Court faced a decision in question of whether Louisiana's congressional map, known as SB 8, violated the Constitution's Equal Protection Clause. SB 8 allowed Louisiana to have two majority Black districts in 2024 for equal representation. Non-Black voters challenged the SB 8 map that race was the sole reason for the passage of the map. The significance of the Supreme Court decision is based on the impact in which it has on Section 2 of the Voting Rights Act. The Supreme Court ruled that the SB 8 map in Louisiana was unconstitutional, racial gerrymandering, which is officials purposely changing electoral district boundaries to give themselves an unfair advantage to win an election. The reason behind the Supreme Court's decision is Section 2 did not justify compelling interests for the Voting Rights Act to create a second major Black district. SB 8 to the Supreme Court failed to meet the state's non-racial political goal of protecting officials in office. Next, there was no evidence citing intentional racial discrimination currently, and the evidence that was presented was about officials who discriminated against Black voters decades before the Voting Rights Act were signed into law. According to the majority in favor of the Supreme Court, there was no evidence of the state using race to discriminate. So, SB 8 was deemed unconstitutional in drawing a district map supporting a second majority Black district. Before the Supreme Court's decision, voting laws could be challenged if they had a discriminatory effect on results. Minorities did not need proof of intent. They just had to prove the effects of racial discrimination in the act of redrawing maps to win elections. Now, minority communities can be penalized for their redistrict plans if they do not prove current discrimination. Also, minority communities will have to present stronger proof of intentional discrimination. Equal rights protection was about equal outcomes, but now that is not enough to work in favor of the underrepresented. Yikes. Here's my take. The Voting Rights Act has been weakened by the Supreme Court's ruling. How could any elected official forget about the discrimination the Black community faced to gain a voice of representation? That was the whole point of creating the Voting Rights Act, to ensure Black communities and other minority groups could exercise their rights as citizens to vote. Now the same law used to help the marginalized has been turned into a weapon against them. That seems immoral and should be unconstitutional. But we must pay attention to the language used in Section 2 of the Voting Rights Act. Section 2 states, no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. The words, the rights of any citizen in the United States, extends beyond the reach of minority communities. Although I must say it is a stretch to use this against underrepresented communities in which the law was created for. Why would an underrepresented community have to prove something if it is evident and obvious based on the foreseen effects it will have on their communities? Having to present stronger evidence of discrimination will make it hard to win in court. Without concrete evidence, it will be a person's word against another, and it will not hold up in court. When we talk about the influence of what the ruling can potentially have nationwide, we must understand states now have more flexibility in drawing district maps. With that freedom comes the power to reduce minority voting. If it can be framed for political reasons rather than racial, the boundaries will be permissible. Chances are minority communities' power to elect their preferred candidates will cause a shift in little to no gain of representation in Congress and state legislature. The Supreme Court proved they can limit the power of the Voting Rights Act. It will continue to happen over time, weakening the opportunity to prevent discrimination while restricting the use of race and policy making. If we examine the history of America, racial discrimination has been woven into the fabric of policy, practices, and procedures. However, it is signed into law that we as American citizens have the right to exercise our votes. The courts and officials cannot take away that from us. This has been another episode, of Broad Scholarly Opinion, where we challenge perspectives, demand evidence, and speak on what truly matters. I am Rodney McNeil. Stay informed, stay critical, and I will catch you on the next episode.